welcome to Tort Talk. The time may have changed, but we will be here no matter what. I'm Mark Ryu, and joined as always by John Robinson and Joe Fantini. We have a massive show for you today. The plaintiff has officially rested in the social media addiction trial of the year. We'll look at what the defense plans to do next, plus a major weight loss drug update and what it means to the U.S. litigation. We're also breaking down the make or break Daubert hearings in the hair relaxer MDL, and a huge update on the Roundup class action approval in Missouri.
A lot of agencies sell services, SEO packages, paid media packages, social packages, but RR Digital doesn't really operate that way. We build acquisition systems while staying tactic agnostic about how they get there. And we're founder owned. It's Mark and I, so we're not going to force your law firm into whatever the agency happens to sell. If that's the kind of alignment you want, check out RR Digital at rrdigitalmedia.com. In the social media addiction trial, the plaintiff has finally rested. We have the defense now with a chance to present their case. What do you think the defense will focus on as we bring this trial hopefully close to its end?
Like you mentioned, John, we just rested the plaintiff's case. I think it went extremely well. We heard from the plaintiff therapist, even had a chance to question Zuckerberg during that initial few weeks of the trial. Now that we pivoted to the defense case, really what they're focusing on so far is trying to prove and show all of the steps they went to make sure that the platform was safe. So they're going to bring forward some of their experts. We're going to hear and learn a little bit more about what they think was adequate and was sufficient to protect the minors. They're already talking about and throwing out numbers for Meta, how much content of the sexual nature is being pulled down every day, constantly, in an effort to show that they're really going above and beyond to protect and keep the kids safe. But what that's not really doing is focusing on the algorithm and how it does impact the kids and whether or not they did everything in their power to really protect the minors like the plaintiff we have in this case.
Based on the information that is available to you, because we know that no one is actually in the courtroom, do you feel like this is heading towards a positive direction for the plaintiffs at this time?
It does. It seems like it was a very strong case presented by the plaintiff. It went a little bit longer than we were thinking. Early indication was we would have had gone to the jury at the end of last week. It looks like we're going to have almost a full week here before it gets to the jury. So I'd be surprised if we have a verdict by the end of this week. Probably by the time we talk next week, we'll have a verdict, and it looks like it's going to be in plaintiff's favor. We'll see how big of a number it is, compensatory damages and punitive damages. Hopefully, if we can score punitive damages, that really sets everybody up for the cases going forward.
I'm waiting for the result on this one. John, I know the policy is on vacation next week. Do not bother me, but please text me an update when the verdict comes out.
You got it. No problem.
All right, moving on to the weight loss MDL. Both the gastrointestinal injuries and vision loss cases are moving forward. We saw also that in the UK, it's a regulatory agency, which is like comparable to the FDA in the USA over here, issued an update warning that semaglutide usage may result in serious eye conditions, NAOIN, that cause vision loss. How do you think this impacts the newly formed MDL?
This is a huge development. We often see that the FDA is a little bit slower to react and a little bit further behind compared to our counterparts across over in the UK and in other regulatory areas. So basically, what happened is the regulatory authority, who's almost like the FDA over there, came out based upon the information and the studies available to them. They've updated the warning now on these medications, saying that it could cause this injury, this very rare eye condition that you mentioned. So basically what I expect to happen over the next year or 6 months, we're going to hear from the FDA. And then if they find that there is this correlation, then they're going to update and issue a black box warning, which basically is going to prevent the defendants from raising the preemption argument, which for sure they're going to charge. So that would basically establish the correlation between the medication and the injury, making the cases much easier for the plaintiffs, pretty similar to what we're seeing going on in the Depo-Provera litigation, where we had an updated warning label during the actual litigation, which really tilts in favor of the plaintiffs.
Yep, making progress on these weight loss drugs. It's good to see that report come out of the UK. In hair relaxer, our next case It is now make or break time in the MDL. At a recent case management conference, the judge was focused on Daubert. What can you tell us about the progress being made there?
Like you mentioned, John, we just had a case management conference in the hair relaxer litigation. Pretty much all of the attention's focused on Daubert. So this is when the case is either going to be made or we're going to end up having some serious problems. Basically, what we have going on is there's 10 separate plaintiff experts. Each one of them are going to be challenged by the defendants. The defendants have a certain amount of pages to challenge each one, and then the plaintiffs can come back in a response, and they're limited to 10 page per expert or 100 pages total, and then the defendants get a chance for a reply brief totaling 50 pages. What we'll then see is ultimately get to a hearing, and then the judge is going to rule whether or not the experts come in. Not all 10 of our experts are likely to survive. I'd expect some of them to get kicked out, but that's why we have so many. You usually don't want in an MDL to just be relying on one expert, so having a number of them is really good. But we need to remember in this litigation, we're also going after 3 separate cancers. So it will be interesting to see which experts come in and if all 3 cancers survive. We'll likely have the hearing some point in April, and then before the summer, we'll get the ruling. And then that's really going to shape the framework for the first Bellwether trials early in 2027.
And remember, this was reigning number one on our Tort Talk Power Rankings. So we will see how these Daubert hearings go to see if it retains its crown.
Yeah, really important hearing. I'm still feeling good. All of the buzz that's coming out of it is very positive. We'll see how these Daubert rulings go, but if we can get 6 or 7 through, it's looking really great.
We usually don't talk about the state, but it's the focus of this next update, Missouri. So Roundup, preliminary approval was granted in the Roundup Missouri class action. What does everyone need to be doing with their inventory now?
Yeah, this is moving really fast. So
Way faster than I thought it was going to.
yeah, you and everybody else. So the proposed class action was filed, and then 15 days later, the court entered a preliminary approval order granting the class action. So preliminary approval order isn't a final approval order. Instead, it's the judge saying that they believe that the framework and the terms of the settlement are reasonable. What everybody really needs to know is that there's a 90-day time period for anybody to opt out of the settlement. So if you want to opt out of the settlement, meaning you don't want to go forward with the settlement, you want to move forward with your case individually, go forward in state court, you have to get a wet signature. So an original signed document, not DocuSign, and also submit a copy of your ID and some other requirements related to your specific case, or your case is going to be included. And then we end up having the fairness hearing, which is going to be in July, where people get to challenge with objections or opt-outs. But really important, you only have 90 days to get everything together for your inventory. So you need to be getting in touch with your clients, reviewing the medical records, seeing which tier they would fall into under the proposed settlement, and then counseling them and deciding whether or not they want to opt out or move forward with what we have in place right now. This is moving at breakneck speed. I think part of the reason is because we have this appeal up on the Supreme Court. We're going to have oral arguments at the end of April and a decision before the end of June. It looks like the court and the parties wanted to get everybody tied in before we heard from the Supreme Court about whether or not these claims are preempted. So moving rapidly. We'll give you guys updates as we move forward, but make sure you're reaching out to the clients right now, have all the medical records, and going over the different tiers to see if it's a good option for your clients.
Let me know if I heard you correctly. So firms have 90 days to get a wet signature from their clients.
90 days if the plaintiffs want to opt out, meaning if they don't want to participate. If they do want to participate, you don't need that wet signature, but it's really the clients that could have a really big case, somebody that has a lot of exposure, really big damages, maybe a recurrence of cancer, a lot of chemo treatment. Those are potentially the cases that you'd want to reach out to your clients, particularly to see if they want to go forward with the settlement or they'd elect to stay in. So, yep, there's certain requirements related to this opt-out period we're in.
Whew. That's a lot of stuff to get done in 90 days.
Thank you for answering the question before I even asked it. I was going to ask you, is it that people with better cases, potentially more damages, are the ones that want to opt out, or the opposite? And it seems like if you've got those really good cases, you may want to contact your clients directly and make sure that they are getting full attention on those individualized cases versus getting lumped into the class action. But I did want to ask you, Joe, what happens as this class action moves forward? And then what if the defense gets a favorable ruling from the Supreme Court? Could they pull back on what they've already proposed in the class action settlement?
Potentially, but I think that'd be unlikely. So the defendants do have a termination date, which gives them the opportunity to basically say they don't want to go forward with the deal anymore. But it seems like they're really pushing the settlement and want to get it resolved. So they're saying there's 60,000 cases in Missouri that would be impacted by this. There's some cases going on in New Jersey or Philadelphia or in the MDL, which don't see like they'd be included. There's a potential to get involved, but it seems like this is a deal Monsanto and Bayer's really driving. I think from their perspective, they want the deal to happen.
Yeah, put some finality on it.
Exactly.
I think that's the end of the list, right?
That is the end of the list. You want to take us home?
You got it.
Me?
My back hurts from carrying this team. Oh.
All right. Thank you, Joe. Thanks, Mark. Another great week here. Best 10 minutes in mass torts each week on Tort Talk. We will see you next week for another episode of Tort Talk.